All right, good afternoon, everybody. I hope everybody can hear me well. This is working. So we'll get started. Thank you all for attending the Housekeeping Pettis and Schwab webinar on compensability and the arising out of requirement for the compensability of workers' compensation claims. Today, I'm your presenter, Mike Riedhammer. I'm the partner and leader of the workers' compensation department here at Housekeeping Pettis and Schwab. A few housekeeping notes I need to go over. So attendees, you are all in listen only mode. But if you have any questions for me, please feel free to use the Q&A button and I will answer as many questions as we can get to. Probably I'll try to save everything till the end. We should have a couple minutes left over at the end and I'll answer whatever questions you all might have. Also, if you're having any technical issues, please use the Q&A box and Carrie from my office, who is monitoring, will try to help you out. There's also going to be a couple of supplemental materials that we're going to put up in the Q&A section. Some of the cases that we'll be discussing today we'll put up there so you could download them if you want to look at them more yourself. And of course, if there's anything that we don't put in there that I talked about today, just feel free to let me know and we'll get you copies of everything that we talk about today. This session qualifies for one Florida Financial Services Continuing Education credit, which I'm sure you are all very concerned about. So a certificate of completion will be sent within 30 days of this event to each person that submitted their license number at the time of registration. So if you didn't submit your license number, or if you want to make sure that you're going to get the credit for being here, please email Carrie at my firm. Her email is crydder at hpslegal.com. And if we can put that up in the Q&A box as well, so you can see that there. And of course, if you have any trouble, you can always email me at any point in time and we'll help you out. All right, well, with that stuff being said, let's go ahead and start talking about what we're here for today. Compensability and the arising out of requirement. So you all know probably that there has been a lot of talk about the arising out of requirements since the recent Valcourt Williams case. And that is something that we're going to focus in on eventually about midway through the presentation. But what I want to do is kind of go over the initial statutory requirements with you. We'll talk about some of the historical compensability handling cases that kind of guide us as we're going through are determining whether things are compensable or not. And what I'm going to try to focus on today largely is the idiopathic type claims that we come across so often, those unexplained faults and how the arising out of requirement impacts those cases. After we discuss some of the historical handling, we'll talk about Valcourt Williams briefly. Then we're going to talk about how the workers' compensation judges are handling these cases when the defenses of arising out of comes up. We'll go through a bunch of fact patterns. There's been several cases over the last 2 years since Valcourt Williams came out that discuss that case in particular and talk about the arising out of requirement. And then I want to finish up today by talking to you all about some things that I think are really important in the claims handling part of the cases, things that you as adjusters or supervisors out there can really make sure you focus in on when you're looking at these cases and try to decide whether or not you have an arising out of defense and whether or not there's some sort of issue you should be looking at and whether a case is compensable or not. Getting into the statute, obviously section 440.091 tells us that workers' compensation benefits are due when there is an accident resulting in an injury, quote, arising out of work performed in the course and scope of employment. So we all know that phrase, I think, pretty well. There's been lots of discussion over the past about course and scope of employment. That usually isn't too much of an issue these days. I think what we're really going to focus more on today is the first part of that sentence, the arising out of. portion, which actually has its own definition in 440.0236. There we know that arising out of pertains to occupational causation. That's a key phrase. I think that's going to come up later on in several of the cases that you'll see as we discuss it. And I think that kind of gets renewed in particular attention after the Valcourt Williams case. But occupational causation is something that really we need to keep that phrase in mind as well. The definition goes on to tell us that an accidental injury or death arises out of employment if work performed in the course and scope of employment is the major contributing cause of the injury or death. So again, we have major contributing cause issues in looking at this as well. And that's going to be something that the courts focus in on too. So we're going to be talking about that as well. All right, so historically, going back to 1989, the Supreme Court comes out in the case of Leon County School Board versus Grimes and tells us something about when cases are compensable. In this case, we had a claimant who fell and fractured her ankle at work, but the fall occurred because the brace that she was wearing, because of her polio condition, broke. So she's wearing a brace because she has polio. The brace breaks, she falls down, breaks her ankle. This case went up to the Supreme Court, where they tell us that injuries at work that are a result of conditions personal to the claimant and are not caused by the place of employment are not compensable unless there's a showing of increased risk or hazard attributable to the workplace. So there's a lot of phrases in there that I think a lot of us are familiar with from issuing denials and responding to requests for compensability. Obviously, ultimately in this case, the Supreme Court tells us that compensability is denied. The only cause for the claimant falling was her own personal condition of having had polio and she got a broken brace. There's nothing at work that contributed to that or that caused it. So that case is not going to be compensable. Flashing forward a couple of decades, I'm going to jump ahead to 2011. We got the Century Insurance Company versus Hamlin case. Here, the court, the first ECA, actually does kind of focus in on this arising out of language. They tell us that a condition arises out of employment when the employment necessarily exposes the claimant to conditions which substantially contribute to the risk of injury and which the claimant would not normally be exposed to during life outside employment. So again, this is where we get a lot of these ideas and these concepts that we all are kind of familiar with when we are saying that something is personal to the claimant or there's no increased risk. These are where that language comes from. So in this case, you guys might remember this from 2011. This is a case that had kind of a different set of facts going on with it. The claimant was at work when he sees that his car is being repossessed from the employer's parking lot. So he runs out to try to retrieve some personal items from it, and in the process gets run over by his car and injured. The first ECA in this case found that compensability should be denied, again, because nothing about going out to retrieve personal items from your car while it's being repossessed arises out of employment. Okay, this is something that the claimant could have been exposed to during life outside employment and probably would have if the tow truck driver knew where the claimant's driveway was or where his car would have been parked any other part of the day other than when he was at work. Compensability, like I said, is denied in that case. The next three cases that you see up there, Caputo, Walker, and Ross, all came out in 2012. And I, for one, remember these cases coming out very well because I actually had a case that was very similar to this, to the fact patterns that we're going to talk about here, particularly in Walker, where it was basically an idiopathic fall or idiopathic condition or something personal to the claimant that might have caused the injury. And in these cases, all the claims were denied, and the judge of compensation claims in all these cases found that the denials were appropriate and that there was no compensability. But the first ECA kind of felt differently, and we're going to talk about a couple of these. So Caputo versus ABC Fine Wines and Spirits. In this case, the claimant was cutting down shelves at the employer's place of business. when he fell and hit his head. He doesn't know how he fell or what caused him to fall or how the accident occurred, but he fell and hit his head, and the hitting of his head was definitely a result of the fall, and that was the injury that he was seeking to have be compensable. Curiously, he did have a history of at least one prior fall from having a loss of consciousness. So the employer carrier denies the case based on the pre-existing or idiopathic condition having caused the fall. Like I said, the judge of compensation claims agreed, denied the case, and it goes up on appeal where the first ECA reverses. And here they focus in on the arising out of language. And they tell us arising out of requires two factors. And they get this from the definition largely. The work must have been performed in the course and scope of employment, we know that, and the work must be the major contributing cause of the injury. So we know now the major contributing cause is something you need to look at when talking about arising out of and whether or not you get that. So here the judge found that, or the first ECA found rather, that this case was compensable. The claimant was certainly in the course and scope of his employment when he had this fall and hit his head. And that's really the only thing that he was doing. And the fall on the shelving and the damage to his head was the major contributing cause of the injury. So because of that, we meet this arising out of. And in this case, there was no real support or testimony other than about a prior condition, other than the claimant had a prior fall from loss of consciousness, but there's no explanation as to what caused it or how that might be contributing to this particular accident. So because of that, we have only one known cause. Major contributing cause is this accident and the injury. So that is going to be a compensable case now. That is followed up in the Walker case. So we have Walker versus Broadview Assisted Living. That's another first ECA case. Again, these are all from 2012. These three cases, Caputo, Walker, and Ross, came out, I remember correctly, all within a couple of months of each other. They seem to be like one after the other coming out. And I remember, like I said, them coming out because I had a case that was almost exactly like this leading up to a final hearing later in 2012, which ended up not going so well for me because of these cases. So we have in Walker, the claimant was asked to drop off a package by her employer at the UPS. After she leaves, go to the UPS, drop off this package for shipping. So she puts it in her car. But later on in the day, a UPS driver comes to the place of employment, delivering another package. So she runs out to her car, gets the package, gives it to the driver. So she fulfills that job requirement for herself. After she gives the package to the driver, she's walking back to her desk. She turns a corner in the hallway and she feels her right foot slip from under her, causing her to fall. The result is that she has a rotator cuff tear in her shoulder. Here, there was no pre-existing condition that caused the claimant to fall, but apparently there's also nothing that was employment related that caused the fall. There was nothing that she was necessarily doing other than walking back to her desk. There was nothing on the floor, no water, nothing that she tripped over, no bump in the carpet, nothing along those lines. So the employer carrier denies compensability. Again, the judge of compensation claims agrees and says this is not a compensable claim. But the first ECA follows Caputo, the case we just talked about, and determines that since there's no competing cause of the accident, work is the only cause, therefore it's the major contributing cause, and the arising out of condition is met. So here we have, again, there's no pre-existing condition, there's nothing else, it's just claimant just slips and falls for no reason at all. But the only thing she was doing at the time was working, going back to her desk after having delivered a package. So it's a compensable claim. Last in these kind of series of three cases is the Ross versus Charlotte County Public Schools case. Here, the claimant fell when her foot got caught on linoleum flooring while she was walking quickly between two classrooms. And I think it's curious that the first ECA focuses in on the walking quickly between two classrooms because one of the things we're going to talk about later is that the facts of these cases and the drilling down on some of the facts of these cases really gets to be important when making determinations on compensability. And that's something that you all as adjusters and handling these cases can really kind of set the tone for and find out very early on when you first get these claims in your office. So the claimant was walking quickly between two classrooms, has a fall, doesn't know what caused her to fall other than she said her foot caught on linoleum. So she did report, honestly, that she had a mild vestibular problem prior to this. And the carrier ends up denying compensability, arguing that the fall was personal in nature and not caused by work. Unfortunately, they had no medical testimony to support that. But nevertheless, the workers' comp judge, the JCC, found that because there was no increased hazard from the workplace, compensability should be denied. So the JCC denies compensability, but the first DCA gets a hold of it, and following Caputo and Walker, they reverse and saying again that there's no competing cause, there's nothing else that caused her to fall. Again, we have no medical testimony about this vestibular problem the claimant told us about. But because there's no other cause that could be substantiated, the only thing she was doing was walking quickly between two classrooms, that's working. She satisfies the major contributing cause requirement, and the accident therefore arises out of employment and it's compensable. So following, I think, these three cases in particular, the takeaway that I always had was that the employer carrier has the burden pretty much to show that there's a pre-existing or an idiopathic condition, and they got to come in and show that by some sort of medical or expert testimony in order to deny a case based on this kind of arising out of situation. So what I want to do now is kind of shift over and see, does the Valcourt Williams case change that in any way? So you're all familiar with the Sedgwick versus Valcourt Williams case. We'll try not to talk too much about it, because I'm sure you probably have heard about it in several other seminars over the last 2 years. This case came out in 2019. They tell us that the injury must arise out of employment, and that to arise out of employment, there must be occupational causation. There's that phrase from the statute that I don't think ever really got a whole lot of play before this case came along. But certainly after this, that's one of the things that I think we need to focus in on in that language, occupational causation. Do we have that? And the Valcourt Williams case gives us some more guidance on that. To have occupational causation, the employment must expose the worker to conditions which substantially contribute to the risk of injury that the injured worker would not normally be exposed to during non-employment life. So it's kind of like what we've seen already with the increased hazard, that kind of language. It's along the lines of the same thing, but now we know that they're telling us occupational causation is basically that type of test that we've been looking at. The Valcourt Williams case did actually recede or kind of overturn a lot of cases that had been discussed in the past by the first DCA. But what they didn't do is they did not disturb any of the rulings from notably Caputo, Walker, and Ross. So those three cases are still left intact after the Valcourt Williams case came out. So anytime we have an idiopathic condition, I think we still need to kind of look at that and not just focus in on arising out of, but prove that there is a pre-existing or idiopathic condition that caused the accident. So going on from there, obviously we've had some time now since 2019. There's been a host of workers' compensation cases coming out of the various JCCs from around the state. Some of these may be some of yours, I don't know. But we're going to talk about a couple of them. What I want to kind of do is go through some fact patterns from them, ultimately leading up to the end of the discussion today with kind of focusing in on some things that you all can do in your investigations. And there's a lot of very fact-specific things that the JCCs focus on in these cases that I think really are the deciding factors. So first we have up here Ugalde versus Garden Memories. This case came out in early 2019, not long after Valcourt Williams. This was decided by Judge Young. I believe she's over in Tampa, I think. Here we had a claimant that was walking down a flight of stairs at work. She was talking with a coworker, and we know from the facts that she was talking with her coworker about work-related issues during employment. She lost her footing and fell. She did have prior complaints, and this is again a claimant who's very honest with her prior conditions. She had prior complaints of foot pain and balance issues, and actually had fallen walking on flat level surfaces before. So the employer carrier denies compensability based on the idiopathic condition, and that condition being something personal in nature to the claimant, and that being the cause of the fall. But in determining whether the accident arose out of employment, the judge cites to Valcourt Williams and finds that there needs to be work-related risks that cause the accident and the resulting injuries. So here we had some testimony, and this is again where really the judge is focusing on some of these fact-intensive inquiries. There was testimony from the claimant as well as an eyewitness that the claimant was distracted by her work-related discussion going on, and when she turned to answer a coworker, she missed a step and fell. So those facts right there are enough for Judge Young to find that this is a compensable case. She's obviously in the course and scope of employment, and the accident and injuries arise out of employment because she's distracted while she's walking down the steps, and that's the cause of her missing a step and falling to the ground. Again, there didn't seem to be a lot of support for the claimant's pre-existing condition given to the judge, so I think that certainly was an issue as well. But again, we're going to continue on and see how these very, very intensive fact inquiries play a role in how the judges find out and determine compensability in these cases. So next we have Silverberg versus Palm Beach County School Board. This is a Judge Stevenson case from later in 2019. Here a claimant was a teacher. He was sitting in a classroom. When he stood up, he had no feeling in his left leg, and that caused him to fall. He had no explanation as to what caused him to fall other than the fact that he couldn't feel his left leg. So here we had some medical testimony. The employer carrier's IME came in and testified that the cause of the loss of feeling was due to a brief compression of nerves from sitting in one position. He explained that this is a benign condition that can happen to anybody, anywhere, anytime that they're sitting in a particular position for too long of a period of time. The claimant had an IME who basically just agreed with that, said, yeah, that's true. That's what happens if you sit in one position for too long of a period of time. So yeah, somebody's telling us it remains on appeal. That's going to be how I end up with this. Yes, this case is on appeal, as we'll get to, and we still don't have an answer on this one yet. But Valcourt Williams, I think, was a big topic of discussion. And the judge of compensation claims said that we need to focus our attention on the occupational causation. There was nothing about the job that increased the risk of injury. He said this could have happened to anywhere, anytime that the claimant sat for too long, or not even for any length of time necessarily, because there was some question about how long the claimant had been sitting for in this case. But then when he stands up and has no feeling in his leg, he could fall, and that's just something that could happen anywhere, anytime. So that's what the judge found. There was nothing in the classroom that contributed to the fall. The claimant tried to argue under the Caputo case that we talked about before, that because there's no other cause of the fall, that the claimant should be presumed to be having had a compensable accident because it happened at work. And I think they kind of try to expand on the Caputo case a little bit there. I don't think you get a presumption of compensability. But when there is no other cause for the fall, you kind of, yeah, maybe you meet that major contributing cause requirement. But here the JCC said, no, that's not really the fact. We do have another cause. We know what caused the claimant to fall here. And based on two IMEs, the carriers and the claimant's leg went numb due to a nerve compression. There was nothing about work that caused that. And again, everybody kind of agreed that could have happened anywhere. So the judge denied compensability, the claimant appealed, and as we just said before, that case is still up before the first DCA, and we're waiting for a decision, which, the part of the bad thing about these cases going up to the first DCA is sometimes they take up to 2 years before you get a decision, so we don't know what's going to happen with them. A lot of times, and I think more frustratingly for people on both sides of the fence, is that a lot of times the first DCA just gives a PCA in these types of cases, or a per curiam affirmance, where they just let the lower court's decision stand without giving any written opinion or any rationale for deciding the way they did. Those are the most frustrating things I found in my career, my cases that have gone up on appeal, just not knowing why they decided something a certain way after having something sit before them for maybe a year. So the next cases, so the next two cases, both came from Judge Weiss on the same day, actually, December 23rd, 2019. He issued two different workers' compensation claim orders. This first one, Tola versus Winn-Dixie, dealt with a claimant who was obviously an employee of Winn-Dixie working at the deli counter. She was on the customer side of the counter, actually filling the wing bar when she saw that someone was waiting to be served over by the deli counter. So she walks quickly back towards the counter when she falls. She has no idea why she fell. There's nothing that caused her to fall. There's no water on the floor. She didn't trip over a display. There's no explanation, and she doesn't know why she fell. She just fell, went down. She actually finished out her day, but the next day she goes to the hospital and learned that she had a fractured hip and actually required surgery. The employer carrier in this case denied the claim, saying that the accident did not arise out of the course, or did not arise out of the claimant's employment. And they were relying on Valcourt Williams in saying that there was no occupational causation and there was no increased risk brought by the employment. The claimant in this case, though, points back to Caputo, Walker, and Ross, and says that to meet the arising out of requirement, the work must be performed in the course and scope of employment, and the work must be the major contributing cause of the accident or injury. And the judge, citing those cases, Caputo, Walker, and Ross, agrees. So he says that they all stand for the proposition that an unexplained or idiopathic fall in the absence of a pre-existing condition satisfies the major contributing cause requirement where the injury occurs while the worker is engaged in the duties of the job. And that's what happened here. So we had a claimant who was working, filling the wing bar. She sees a customer waiting by the deli. She turns and goes back to the deli to wait on him when she has her fall. She was in the course and scope of employment. She was doing nothing else but working, and there's no other cause for her having the fall. So the judge finds that it's going to be compensable. So there was actually video in this case. The employer carrier was arguing that the video clearly established that she simply collapsed without any work-related condition contributing to the same. But the judge actually disagreed and said that when he looked at the video shows exactly what the claimant testified to. She was walking quickly back to the counter to serve the customer. And the judge actually found that when the claimant's feet were moving in different directions, they corresponded to her being involved in one task and then going to see another task, both of these tasks being work-related. And so we get into the arising out of requirement being met. So the JCC finds for the claimant here and awards benefits. And really, I think, again, we look at the details here, and the claimant telling the judge that she's doing one work activity and then quickly changes up to go and assist a customer, and she's doing another work thing, that really matters in this case because we meet that major contributing cause requirement. And the judge, not only with that testimony, but also seeing things obviously vastly different than what the employer carrier saw on the video, weighs very heavily on them. Another thing in this case is that the employer carrier doesn't point to any other cause. I think, again, going back to those Caputo, Walker, and Ross cases, the carrier is going to have to show something else caused the fall a lot of times in order to deny compensability and have that stand up before the workers' comp court. So the second case, Warren Young versus CMEX, that came out from Judge Weiss on this same day, starts out a little bit differently, again, with the judge pointing to some pertinent facts to the case. In the opening paragraphs of his decision, he points out that the claimant is 55 years old, approximately 5 feet 9 inches tall, weighs 252 pounds, and has been this weight for a very long time. So I think you can kind of see where this case is going, what the judge is going to focus on. So the claimant was a truck driver. He was delivering some things to a job site. When he gets to the job site, he's supposed to get out of his truck, walk over to the supervisor, turn in the ticket, I guess telling what he has on the truck. The supervisor tells him where to take the truck on the job site, and then the claimant is supposed to walk back to his truck and deliver the goods to wherever he's supposed to go to. So in this case, he did that. The claimant gives the ticket, is told where to go, turns, walks back towards his truck, and is walking towards his truck when his knee suddenly popped. The employer in this case testifies that, yes, it's a dirt site, but it's level ground and completely flat. So we have claimant walking on a flat, level surface when his knee pops. He's in the course and scope of his employment, but does he have a compensable claim here? Eventually, he goes and gets medical treatment. And this was all pretty much on his own. I think he had medical treatment. They talked about, there was a lot of discussion about severe degenerative changes in his knee, which obviously we could see coming based on the judge's description of the claimant at the beginning of his opinion. He eventually has to have a knee replacement surgery after this incident. The employer carrier's IME says that the pre-existing changes were the major contributing cause of the need for treatment, while the claimant's IME says 51% of the need for treatment was due to the twisting at the job. And so that is kind of, I think, the death knell for the IME for the claimant in this case, because the judge doesn't believe that that happened, because there's been no real testimony that there was ever a twisting that caused the pop in the knee. The testimony really focused on the claimant walking on a flat level surface back to his truck at the time that he felt this pop in his knee. So the carrier, like I said, they deny compensability, relying on the Valcourt Williams case. They're saying that under Valcourt Williams, the employer carrier is arguing that an accident is only compensable if the employment exposed the claimant to conditions that would substantially contribute to the risk of injury and to which the claimant would not normally be exposed to in non-employment life. But the claimant argues that the employment placed him in a position of increasing dangerousness from the effects of a fall, from being on a ladder and falling, from being near machinery or sharp corners, or pivoting in the sand. But ultimately, again, the judge found that none of those things happened here. So the claimant wasn't falling off of a ladder. He wasn't climbing back into his truck. He didn't pivot on the sand. None of those facts were what caused the pop, and the overwhelming evidence that the judge relied on is that the claimant was walking on a flat level surface when the pop just happened to his knee. So the judge here, in this case, denies compensability. So we have Judge Weiss here in two different cases with the arising out of question, one side going for the claimant and the other side going for the employer on the same day. So what's the difference in the takeaway here? I think really is that clearly Mr. Young, the truck driver, could have been walking anywhere at the time that his knee popped. Anytime he's walking on a flat level surface, even though it was dirt, it was no indication that it was hazardous dirt or there was anything going on there. It was a flat level surface, and he felt a pop in his knee. Tola, however, the clerk at Winn-Dixie, was doing a job-related activity when she turned and changed direction to go do another job-related activity when she fell for no apparent reason. So because she's in that turning thing, she's doing one thing, she's turning to go help the customer, that's part of the job. Walking back to your truck just to get in it and drive along, that can happen to you anywhere, but when you turn quickly to go help a customer who's at the deli counter, that's not something that you're going to be exposed to necessarily in non-employment life. So we can reconcile those two cases, and that's how we look at now arising out of. So again, very fact-specific inquiries need to be made, and that's what the judges are going to look at. The next case I have up here is Castano. This does not involve an idiopathic condition case, but there was a lot of discussion about arising out of. And I think it was just an interesting case that actually recently got PCA'd by the first DCA after it was appealed. But it kind of reminds us that anytime you have a claimant who's getting involved with guns at the workplace, and a situation where clearly they're not supposed to be involved with guns, you're likely not going to have a compensable claim. So in this case, we had the claimant was a building manager for a school. His duties included running the maintenance department, inspecting school grounds, coordinating bus routes. During his time there at the school, he had several conversations with the school's security guard, who was a subcontractor, about purchasing a gun for personal protection. So on the day of the accident, March of 2020, the claimant goes out with the guard to the guard's car to look at a gun that he'd recently purchased. But the claimant adds that he was also out there to do one of his job duties, which was to inspect the parking lot. Nevertheless, it's during the inspection of the gun that the claimant actually gets shot in the eye and ends up losing vision in that eye. I think, thankfully, this wasn't a much worse accident, and frankly, I don't know how that happened, but there was various descriptions of how the accident actually happened, whether the gun discharged or whether the bullet fell to the ground and went off. There was really a very clear set of facts as to how it actually happened, but the claimant ends up losing his eye while looking at a gun in the parking lot. Course and scope of employment was not contested here because the claimant's out there obviously doing part of his job, which is to look at the parking lot, and he's expected to be there. But the carrier denies this accident, saying that it did not arise out of employment. So the judge looks at it very importantly as finding that the employer had a strict policy against guns on its premises, and that actually the claimant, under the guides from the school, would have been required by the guidebook to report this gun to his supervisor. So he shouldn't have been just looking at it in the parking lot. He should have ran back and told his supervisor, hey, our security guard, who's not an armed guard, has a gun in his car and we should do something about it. But the claimant said that he didn't think that really applied to him because the security guard was going to go work at his armed guard job later that night, and so he didn't think it was an issue that he had to be concerned with. The claimant in this case made a lot of arguments about deviation, temporary deviation, and they cited to a lot of the horseplay cases, trying to bring this claim within the realm of compensability, but the judge wasn't buying any of those arguments and really said this wasn't horseplay, it wasn't a minor deviation, this was a major deviation, even if it was a horseplay issue, and it was a major violation of the employer's code and rules. So ultimately the judge finds that the accident and the resulting injury did not arise out of employment. There was nothing job related about this that caused the accident. It could have happened to the claimant anywhere, anytime he's looking at a friend's gun and deciding whether or not to purchase one for himself. Like I said, this case did go up on appeal and a PCA was issued, so we don't know why the first DCA affirmed the way they did, but it seems to make sense and goes along with a lot of other cases that we've seen in the past where there's gun issues on employers' premises that do not result in compensable claims. So getting back to some of our idiopathic condition claims, I have up here next, which I don't think is on the slideshow. It's the case of Santiago versus SBA Communications. This was a case from, I believe, Judge Hedler in late 2020. If anybody's interested, we can get you the site for it. The claimant in this case was a real estate administrator with mostly sedentary job duties. In November of 2019, she was walking to her workstation to start the day when she twisted her right ankle. In the process of preventing fall to the ground, she throws her right arm up as a counterbalance and feels a sharp pain in her right shoulder. She reported the accident at the time, but denied any medical treatment or need for treatment at the time. So over the next week, she goes for medical treatment on her own. She told the doctor that the right shoulder pain initially started a month prior when she was doing a downward dog in yoga class. but that she heard it again when she almost fell at work, but moved the arm in a very fast manner to regain her balance. So after an MRI, she's told she needs surgery, and then she goes back to the employer for treatment, but the claim ultimately gets denied by the employer and carrier in the situation. So there was some, obviously, IMEs were conducted. The employer carrier IME says the rotator cuff did not happen in the incident at work. There's just that mechanism of injury of throwing your arm up into the air doesn't result in a rotator cuff tear. But of course, the claimant's IME said it absolutely did, and it totally happened at work. I guess they kind of discounted the downward dog theory, but the EMA gets appointed and actually agrees with the claimant and her IME, finds that she did sustain a rotator cuff tear at work during the almost fall, that they call it, because she didn't fall, she just threw her arm up in the air quickly, and that's what caused the rotator cuff tear. So we have an EMA now that says it's a condition that happened at work. So the employer carrier maintains their denial, despite the EMA and the presumption that comes along with it, and they say that the accident and injury did not arise out of the claimant's occupation. And of course, they rely heavily on the Valcourt Williams case. There's some testimony here at a couple of different things that I think is important, different points in time during the case. So the claimant testifies at final hearing, and she says that she tripped over the carpet on her way to the workstation. She was wearing sneakers, she was not in a rush, her foot merely got stuck in the carpet and there was nothing that caused her to start falling. And she actually says, quote, "Sometimes your feet can get stuck on carpet," close quote. On cross-examination by the defense attorney at the trial, the claimant was asked, "And that can happen anywhere, right?" And the claimant confirms, yes, that can happen anywhere. She gave a recorded statement in this case where she confirmed that she was not in a rush, that she did not know what caused her ankle to twist. And during her deposition, she further explained that she was walking to her desk, passing by her boss's office. She has to do a little turn to get into her workstation. And she was actually saying good morning to her boss and her coworker when her right foot twisted. But she admitted readily that there was nothing on the floor that caused her to have this right foot twisting issue. It just happened. It was, regular carpet. She was wearing sneakers. Her foot just got caught. So the JCC in his decision points out that the claimant was in the course and scope of her employment since she's on the employer's premises. She's headed to her desk to work that day. But the JCC makes a point to tell us several times throughout his opinion that the claimant hadn't actually started working yet. And he points out in Valcourt Williams, the claimant also wasn't actually working because she was on a personal comfort break. You remember she was getting a cup of coffee when she had the trip over her dog. But he points out, and he goes through great detail with the Caputo, Walker, and Ross cases to point out that all of those claimants were actively engaged in their jobs. But what the JCC finds here is that ultimately, under Valcourt Williams, you got to have that occupational causation. And in this case, there's no evidence that the injury was caused by a risk that came from the employment. There was nothing employment related about the stumble. The claimant readily admitted that her foot could have gotten caught anywhere. She hadn't even actually started working at the time of her accident. And so the judge rules for the employer carrier in this case and denies compensability. This case did go up on appeal, and I believe it also has not been decided on yet. So we don't have an opinion yet on this particular set of facts from the first DCA, but it'll be interesting to see what they do. Hopefully they don't just PCA it and they give us another written opinion. Next case is Cava versus People Lease. Here the claimant is a driver or transporter for Avis Rent-A-Car at the Tampa airport. His job duties include accepting the return of used dirty cars, driving them to where they need to be washed and cleaned, and then returning them to the ready line. So his job involves a lot of walking, primarily on flat level concrete surfaces, for pretty much 8 hours a day. So on the day of his accident, the claimant told to retrieve a car, but before he goes to get the car, he decides he has to go to the bathroom. So I kind of remember the Tampa airport being like this. There's several steel bollards, they call them, or poles that are about 3 feet high in front of the door. They're secured to the ground with a raised metal plate that kind of goes around them. And so the claimant is walking by this area to go in and go to the bathroom when he stumbles and falls onto the concrete surface. There's actually is video of this case that the judge ends up talking about. There's some expert testimony on it as well. So the claimant testifies both at the deposition and through the translator and through the hearing by using a translator. So the judge points out that his accounts of the fall are a little bit different, but it's clear that the judge finds the claimant did not know why he fell or what caused him to fall. The claimant's expert in this case testified that he fell because his left foot hit the steel plate or the pole and was redirected, causing him to fall. So this is an expert they had actually analyzed and viewed the video, and it's one of those human factors experts who are able to make these decisions and arrive at these professional opinions. So that's his testimony, but the employer carrier denies the claim and raises arising out of, as well as course and scope. The course and scope defense gets dismissed pretty quickly because the judge finds that the claimant was in a personal comfort break and he certainly still was in the course and scope of his employment. But the carrier denies that this was an idiopathic fall due to, and they came up with a couple different things here, diabetes or some other pre-existing condition. And they say that because of that, the fall does not arise out of employment. So the idiopathic fall defense ultimately gets denied because the medical testimony that the carrier relied on is really found to be speculative and ultimately rejected by the JCC. The carrier in this case apparently had one IME, got a second one, and then went back to the first IME and had him testify that the claimant must not have eaten or must have been dehydrated, and that was the cause for him to fall. Again, pointing back to diabetes and that being the reason. But the judge points out that there's really no testimony or facts supporting that. In fact, he even points back to the video and says the claimant doesn't seem to be walking in any unsteady fashion. He's just walking along and has this fall. So the carrier, again, they rely heavily on the Valcourt Williams case, talking about the employment not exposing the claimant to conditions that substantially contributed to the risk of injury to which he would not normally expose to during his non-employment life. They point out the fall happens on a flat, level concrete surface and actually on a walkway that is actually open to the public. So the carrier argues that this is something the claimant could have any time. Under Valcourt, the unexplained fall or any fall that happens from a risk or hazard which the general public is exposed to cannot be compensable. But the judge disagrees. Again, they point out specifically in this opinion that the Valcourt Williams case does nothing to disturb the Caputo, Walker, and Ross cases. In this case, neither the fall or the resulting injuries were due to any personal or pre-existing conditions. Again, he just totally doesn't believe the carrier's IME who says diabetes caused it, because there's just nothing to support that. And they point out that the Valcourt Williams case, in looking at it, they were really looking at cases where there was that competing cause of the accident or injury. Denying that, they found that you don't meet that major contributing cause requirement at all. But in this case, there's no competing cause. The claimant was, again, in the course and scope of his employment and walking past these bollards or these plates that possibly caused him to fall, but he has the fall nonetheless, even though he doesn't know what caused him to fall. It falls within the realm of compensability. The judge rules it's a compensable claim, pointing out that there's nothing that the claimant brings to the workplace that contributes to the accident or this injury. This case also is currently on appeal, I believe. It certainly was. I don't think anything came out with it yet. So we're also waiting on the first ECA to give us an opinion on this case. The last case I want to talk about before we discuss some things that you as the adjusters can do in looking at these cases is the Ladley versus Wellington Regional Hospital case. So here the claimant was a diet technician. Her duties include preparing food, delivering food, washing dishes, and putting items away. On the day of the accident, she was actually making salads, had been standing for over 6 hours at this point, was standing at the counter, facing the counter, when she twists, turns, and reaches to her right to pick up a bag of lettuce from a cart when she felt immediate pain in her right knee, which almost caused her to fall. She doesn't trip or slip. She says that maybe her foot got stuck on the floor when she was twisting, but she definitely just has this immediate pain in her right knee while she's more or less just kind of standing there and making salads. The judge looks at, because he doesn't really get a great description of the accident from the claimant, I think, at the trial, he looks back to the note from the Concentra Medical Center, which documents that the claimant comes in, and they say, the patient states today at work site, while she was turning and twisting her body from a standing up position behind the kitchen counter making salad, is when she felt a pop and pain to her right knee. So that's exactly what's written on the Concentra note, and so the judge seems to rely on that primarily to make his ultimate determination in this case. The employer actually provided benefits, ended up denying the benefits within 120 days, arguing injury did not arise out of employment. She did not trip or slip, and she could have injured her knee anywhere that she was just standing and maybe turning. It just happened to happen at work, but there was nothing employment related about it. The claimant argues that the increased risk of injury at work because she's in a commercial kitchen, there's an excessive amount of standing, and that she has to prepare a bunch of meals during the day, that these things do create an increased risk of injury, and that her case should be compensable. So the judge looks at the facts. The claimant describes the work condition as busy. It's like a commercial kitchen. She needs to make 150 meals for breakfast and lunch. And they point out that her home life, her job at home, is that she cooks for 3 people at most. The floor at work is a painted concrete floor with some material in it that's made to make it less slippery, versus at home she has a porcelain tile, which I guess wouldn't cause her foot maybe to get stuck if she's twisting and turning. At work, she has to stand for at least 6 hours a day making these meals, while at home she stands for only 20 minutes at a time. And at work, she has a set schedule and has to keep up with pacing requirements, while at home, I guess the 2 or 3 people that she's cooking for don't hassle her and don't make her rush along and get them meals quickly. So there's actually conflicting medical testimony in this case. Of course, the employer carrier has got an IME who says that the knee injury was not traumatic. It was longstanding and degenerative. But the authorized treating provider in this case, who had treated the claimant under the 120-day rule, and actually viewed the MRI films personally, said that it was an acute injury and was a result of that incident that happened to her on that day. So the judge in this case ends up ruling for the claimant. He actually makes a comparison to a football game, which I think is probably appropriate since we're in the fall here now. And he says that the claimant was in the field of play and was not standing on the sidelines. She made a football move that caused the injury. So again, it's kind of that move like Ms. Tola made when she was working at Winn-Dixie. She's doing something that's work-related. She's on the job, she's moving, doing her job, and specifically something that had to do with her job in this case, actually twisting and turning to get lettuce from another bag over somewhere else. She wasn't like Mr. Young, who's just walking along on a flat level surface going back to his truck when he has his knee pop out on him. She's doing something. She makes that football move. So I think that's obviously why the judge rules in this case. So I think one of the things that we need to look at is obviously a lot of fact-intensive inquiries were done in these cases, and that's what the judges ultimately make their determinations on. So what can be done, I guess, by you guys as adjusters in your jobs, or your defense attorneys as well, how to figure out what to do here. So number one, and I see this happen only maybe about half the times that I get cases, get a recorded statement from the claimant if you can. And when you do that, get as much detail as you can about what caused them to have their fall. When they have these idiopathic or unexplained falls, get as much detail from them that you can. And if you can, get a written description of the accident. I know a lot of times the initial packets that go out to claimants contain a form that they're supposed to write down the description of their accident. I don't think I've ever seen one returned and make its way back into the employer or carrier's file. But if you can get those things, that really does set up the case to give us statements from the claimant as close to the accident in time as we're probably going to get, unless you get emergency room records or concentra records that have another statement in them. Those are also very helpful. But these are going to be the things that I think the judges are most of the time going to rely on the most in making their determinations. They're going to be, likely to be uncoached statements, spontaneous statements, and they're ultimately going to be given most of the times, I think, the most credibility by the judge. So whatever we can find out about the accident and the injury and how it happened right away from the claimant, it's very important. Find out if there's any witnesses. Again, a lot of times I get cases later on and I'm told there was a witness and maybe here's the name, but nobody ever talked to them. We need to find out, are there witnesses? And if there are, get statements from them. What did they see? Really, did the claimant say anything before, during, after the incident? A lot of times the claimant might say something right after the incident, like, man, this is, the third time I've fallen for no reason this week. That's important. We need to know that right away. Let's find out from those witnesses what happened. Find out again, what was the claimant really doing exactly at the time of the accident? Were they involved in something work-related? Were they rushing to do a job? Were they carrying anything that they needed to do their job? Were they talking to anybody at the time that they had their accident? Obviously, that was a key factor in at least one case that we saw today that made an accident compensable. Look at the actual mechanism of injury. Ask about their non-employment life. Find out what they do at home. Do they have the same type of stairs at home? Do they have the same type of carpeting or flooring at home? Again, you get all these facts at the start of the case so you can make your decision, your determination on compensability. And remember, you do have the option of the 120-day rule to explore this. So if you can't deny a case, or you don't want to deny a case necessarily within the first 14 days and you want to accept it and pay and investigate, it's a powerful tool to use, so you don't have to necessarily get stuck with compensability later on if you do find out those facts during your investigation. One thing I would remind you about is the potential tort liability for your employers if you do deny compensability for a case. If it's an accident that happens on the job in the employer's premises, and you deny compensability, the employer could get sued for that accident having occurred. So I think that kind of wraps up what I was going to talk about today. Again, we have not a lot of time here, but we do have some time for questions or comments if anybody has any. Certainly willing to help out now with anything like that. Put up my information there at the end. If you do have any things that you want to email me about or give me a call about, certainly available and open to that anytime you guys want. Just looking to see if we have any additional questions up here. I don't see anything coming in. So since it is exactly 1 o'clock, I think we've gotten our hour for the CEU units in, and we can call it a day then. So I thank you all again for coming and staying logged in. And again, if you need my information, there it is. And we'll hold that screen up there for a couple minutes in case you need to write anything down. But thank you again for coming.